Good morning and good afternoon. I'd like to welcome you all to a LexisNexis complimentary webinar titled A Day in the Life of a Medical Malpractice Personal Injury Attorney. Before introducing our speakers, we have a few announcements. Today's program is not eligible for CLE credit. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. We will be using the hashtag @LexisSmallLaw to have a conversation on Twitter during today's program if you're interested in joining us. Please take note of the survey that is available to you at the conclusion of today's webinar. We ask that you please complete it as it provides excellent feedback for us so we may continue to bring you outstanding programs that meet your needs. Our speakers today welcome your questions. You may submit your questions via the Q&A section of the platform throughout the program today. We will try to address as many audience questions as possible, but please keep in mind all questions may not be answered due to time constraints. No questions will be asked verbally. And now I'd like to introduce our speakers. Brandon Bass of the Law Offices of John Day focuses on helping people who have been badly injured or lost a loved one. His core practice areas include products liability, medical malpractice, and trucking lawsuits. Bob Graziano focuses his practice on healthcare and business litigation at Russell and Andrus. He is a trial lawyer with extensive experience in complex matters in federal and state courts and has tried more than 50 cases to verdict. We thank Brandon and Bob for their time in preparing today's webinar. Gentlemen, the floor is yours.
Hi, good afternoon, everybody. This is Bob Graziano, and I appreciate everybody being here today. Brandon and I have been asked to talk about the day in the life of a medical malpractice lawyer, and so let's advance the slides to our first slide. Back one. In the life of a medical malpractice lawyer, we want to talk today about all phases of working up a case. Those phases include pre-litigation planning, where I like to term that as study and learn the medicine. We're to talk about the selection of expert witnesses, which I believe is one of the most, if not the most important aspect of working on a medical malpractice case. We're going to talk about discovery, focusing on sometimes independent medical examinations, videotape depositions, and expert depositions, and give you some practical advice on those. We're going to talk about motion practice, particularly motions in limine. We're going to talk about then, after the case is ready to go to trial, we're going to talk about the education of the jury at the trial, including voir dire, opening statements, witness examination, closing arguments, and at the end of our presentation today, we've presented some real-life case studies to give some examples of the information that we've discussed. So, advancing to the next slide, we're going to talk about pre-litigation planning. Okay. In pre-litigation planning, one thing that I like to do and that we do in our office, instead of paralegals, we have legal nurse consultants. I don't know how many of you use a legal nurse consultant, but this is an individual who has an RN, usually, and has completed a legal program at an accredited law school to become a certified legal nurse consultant. What we use our legal nurse consultants for is a variety of activities, including the gathering of all pertinent medical records, the organization of those records, the summary of those records, and basically keeping, sometimes the medical records in these cases can get to be 2 to 4 to 10 to 20 volumes of records, and our legal nurse consultant really keeps us organized in that regard. Also, legal nurse consultants assist us in doing some medical research on some of the issues in the case and the identification of expert witnesses. So in pre-litigation planning, really the first thing to do is to obtain, organize, review, and summarize the medical records, and the assistance of a nurse consultant really helps you there. I'll let Brandon talk about from the plaintiff side, but from the defense side, we want to interview our medical providers. We want to understand exactly what happened with the particular patient and identify any other providers or witnesses that we may need to interview in this case. Once we gather all of the baseline information that I just discussed, we want to really make a list and identify the medical legal issues in the case. And by that, what I mean is, are we talking about an informed consent issue in the case? Did the care provider fail to provide informed consent to the patient before a particular procedure? Sometimes it's informed consent. Another legal issue may be the medical necessity of certain care and treatment, or the technical performance of a particular procedure, or the failure to diagnose and follow up on an issue, things like that. So once we've gathered and reviewed and interviewed the baseline individuals, we want to identify those medical legal issues that we believe are pertinent in this case. Sometimes the complaint, again, I'm not involved in the case really until a complaint's filed, but sometimes the complaint will help on those issues, but oftentimes with notice pleading, a complaint doesn't give you all those issues. So identifying those is very important. Next, we try to perform some medical research, and I've given some websites that we go to research some of the issues. And once we've identified the issues, for example, if it's an informed consent issue, one issue may be, what were the pertinent risks and or complications of the procedure given to the particular patient. So we may want to do some research on what those risks are. Have they changed over time and things like that. So medical research is important now, and we'll talk about medical research when we get to the expert witnesses later. Another thing that we do is we do an internet search on our client, witnesses, and prospective experts. One area that we research is licensures. We want to make sure our client is telling us the truth, has a good license. Experts that we consult or have active licenses, and prospective experts that we are hopefully going to hire in this case, their licenses are in good stead. And then some other witnesses that we've identified, you may want to do some internet research on them. Sometimes Facebook, LinkedIn, you have to be wary of your ethical requirements on those social medias, but we routinely check social medias, particularly of the plaintiffs in the case, and what they're posting on social media. Then we want to retain and consult appropriate expert witnesses. We'll talk more about experts later, but once you've identified the issues, it's been my practice to retain those experts who are most qualified in a particular area of expertise. We want to do that and get those people on board as soon as possible, because those experts help you prepare this case. And I like to think that when I get a case, I'm preparing for trial immediately, and those experts help you do that. I've also found it's very important to study and learn the medicine, and what I've also learned is learning the medicine includes the correct pronunciation of the medical terminology. I can't tell you how many times that an opposing attorney can't even pronounce the medical terms, and I'll tell you, you lose a lot of credibility in front of the jury when you can't do that. One example I have here in the slides is a homonymous hemianopsia, which is a vision issue from the optic nerve. The lawyer in the case could not pronounce that the entire trial. Also, laparoscopic cholecystectomy with the removal of a gallbladder. So it's very important to study the medicine, learn the medicine, and correctly pronounce the medical terms to give you credibility in front of the jury. And then the last part was sometimes in our cases there are some white-collar or health white-collar issues, whether it's Medicare billing or something like that, and we want to make sure that we're we coordinate that with our white-collar partners to make sure that there are no missteps in the case. But that's really the pre-litigation planning that we do in order to begin to get this case ready. Let me turn it over to Brandon to talk about the evaluation of a case.
Thanks, Bob. On the plaintiff side, the case evaluation obviously starts as soon as a call comes in from a potential client. And I would caution anybody looking at a potential medical malpractice case or any issues that could dive into medical malpractice, even if you think it's straightforward, assume your client is telling you the exact opposite of the truth. At the end of the day, the experts are largely going to, and the jury is largely going to, defer to what the medical records themselves say. If you can't prove the case from the records, you are biting off a lot of time and money on the hopes that a jury takes your client as being more reliable than a doctor and all the doctors, nurses, and everyone else at a hospital, etc. Assume what your client has told you is an innocent, complete misunderstanding of the medicine and what happened to them, that they were going through enough that they'd have everything wrong, and focus on whether you can prove it entirely from the records. Obviously, that's a rule, and like every other rule in the law that has exceptions to it, there are circumstances where the records are patently untrue. I've seen cases where the records show that a nurse continued to check on a patient for 3 hours on a half-hour basis, continued to do so for 3 hours after the patient had died, noting each time in the chart, patient looks fine to me. You don't have
That's tough from my side.
You don't have to take the patient's, the medical records as gospel, but by all means, assume your potential client's family members, lay witnesses, etc., are all wrong, and evaluate the case from a hard defense standpoint. You want to look at how strong the liability is and how strong the causation is. If your experts that you consult with tell you something like, well, if X is true, then you might have a good case. That's not a strong case. Now you're relying upon getting evidence down the road. If they say, well, if the defendant doctor says he was aware of X, even though it's not noted in the chart that the patient disclosed it to the doctor when the doctor was treating the patient, now you really, really have a huge piece out there. And you can assume that by the time you're taking a deposition of that defendant doctor, even if the defendant doctor doesn't recognize the issue, after good coaching by defense counsel and discussion, they're going to know you're not going to sneak up on anybody with that type of a question. So look at, is it strong on liability, and is it strong on causation based upon the records themselves? Consider how many defendants there are. I can tell you from experience that the cost and time of litigation rise exponentially with the number of defendants. Coordinating calendars goes up based upon the number of lawyers that are necessary in a case. And even if defendants, if you have 3 doctors, all of whom have an incentive to point the finger at one another, and you might hope that one of them will end up having to be thrown down by the other 2, experience tell me that what they will do is they will gang up on the plaintiff to the extent possible throughout the case. Don't assume that because you have multiple defendants, that means multiple insurance policies, and that means multiple sources of recovery, and take a shotgun approach. I would much rather have a single defendant case any day of the week than to have multiple defendants in a case. The more there are that are necessary or likely to be brought into a case, the more stringent you need to look at whether it's a case you want to jump into. Along the same lines, you want to take into account how many experts are needed. It's not enough in any jurisdiction I'm aware of to simply prove that a defendant health care provider did something wrong or did something that was grossly unacceptable within the medical community. You also have to prove causation. One way that that can bleed into multiple experts is in a case where the defendant healthcare provider failed to consult or failed to bring in another specialist. For example, if an ER doc fails to bring in a specialist, a cardiothoracic surgeon or what have you, it's also going to be incumbent upon the plaintiff to prove what that cardiothoracic surgeon would have done with the information. You can't just prove that the ER doctor should have brought in the surgeon. You also have to prove that the surgeon would have recognized what was going on with the patient and treated them. That's going to require another expert from you at the outset of the case. Many times you need to have causation experts. You need to have someone who specifically says, an infectious disease doctor, for example, in an infection case, that regardless of whether treatment was performed, you have to prove that the treatment would have made a difference in the outcome for this patient. And in many circumstances, in some circumstances, you need to go ahead and, at the outset, prepare for experts to rebut causation defenses or other defenses that will be brought up. For example, it's common in a birth trauma case to have a placental pathologist review the case. Most of the time, that placental pathologist will never come anywhere near a courtroom. But Murphy's Law, the one time you don't know what a placental pathologist will say, is the one time where you've gone on into a case, have paid 5 or 6 other experts, and have gone through a year of litigation only to find out they might have a silver bullet against you in saying that this baby was likely to have defects regardless of bad treatment in the labor and delivery room. Taking all those things into account, you want to figure out, do you actually have the resources to devote? I think Bob can tell you as well on the defense side, and I know Bob does plaintiff's work as well. On the plaintiff side, where you're responsible for every piece of the puzzle, medical malpractice cases eat your money and your life. The amount of time necessary is so much more than even a complex regular personal injury case. There are so many moving parts. Figuring out whether you really have the resources to devote, and lastly, whether you want to devote those resources. Is the juice worth the squeeze? If at the end of the day you can get a victory that is worth slightly more than minimum wage on your hourly rate for how long it took you to get there, and it took you in the process to post up $100,000 worth of capital for hard costs to reach that point, you would have been much, much, much better off going on vacation and investing the money in the stock market in the meantime. Make sure the juice is actually worth the squeeze before you dive into one of these things. I can save everybody on this call $1 million right now. Make you $1 million by just turning down the next 10 medical malpractice calls you get. You'll be better off that way. Bob, you had something to add?
Yep, Brandon, let me just add 3 quick points to your wonderful information. One is, I know there are folks from different states. Know your state rules and whether you have any pre-filing requirements from the plaintiff side. So in Florida, where I am, you have to have some pre-suit interaction with the defendants. In Ohio, you have to have affidavits of merit, or you can't bring the case, or the case will be dismissed. So know your state rules for any pre-filing requirements, number 1. Number 2 is, Brandon's very correct. As a defense lawyer, I defend the case sometimes on causation. I may have to admit liability, and I have an example of that later, but defend it on causation. So be sure that you have all of your elements covered, your standard of care, your deviation, your causation, and your damages, because as a good defense lawyer, I can knock any one of those out and I win. And third, with respect to Brandon's statement about how many defendants, you need to weigh the risks and the benefits, because I'll tell you, the one thing I do like as a defense lawyer is an empty chair. I have a case right now where one defendant was not sued, who I believe should have been, and should this case go to trial, that ghost defendant is going to be an empty chair and carry the day for the defense in the case. So those are a couple additional points to what Brendan had to say.
And finally, in terms of is the juice worth the squeeze, I'll tell you, we generally have a test, and I'll soften it up for the purposes of this webinar, but it's an oh crap test. If we don't look at the liability and say, oh crap, I can't believe that happened, and if we don't look at the damages and say, oh crap, I can't believe how bad this is, generally we turn and run. There is a question from somebody asking about state statutes or other rules allowing a patient to insist that a provider have correct medical records. I will tell you, I'm not aware of any similar provision in Tennessee, the jurisdiction where I practice. I can think through probably the same strategy decisions about whether it's better to show an error during a deposition or a trial and versus having a record corrected over objection pre-suit, as many of you can, but I've never had experience in doing so, and I'm not sure if Bob has it in the jurisdiction he practices in.
I have not.
Okay.
I thought.
Bob, I'll hand you off for the next slide.
Okay. All right. Whoop. I think it's one back. We're going to talk a little bit about selection of experts. We started to talk about this briefly in the last section, but as I indicated, identify the medical legal issues in the case. So in other words, is this a liability case that it's going to be, is it defended on standard of care? Are you defended on causation? And what sub-issues? Informed consent, failure to diagnose, delay in diagnose, technical performance, things like that. Identify your issues, perform some medical research on those issues, and once you're ready, put together a list of potential experts with the right credentials. Who's writing the peer-reviewed literature on these topics? Who's at the cutting edge of these issues in the medical community? That's the list you want to prepare, and from that list, what you do is, you basically call. You get a hold of, you find where they are, if they're at a prestigious medical center or a hospital system or somewhere else. You look them up on the internet, you find their office, you ask for their nurse or their medical assistant, and I found those folks are very friendly. Hi, I'm Bob Graziano. I'm representing ABC Hospital in this particular case. We have an issue regarding a pulmonary embolism, and I understand that Dr. Jones is a highly regarded expert in that field. I wondered if I could have a few minutes of his time to consult on the case. 9.9 times out of 10, you'll get a call back saying yes, set up a time, or send an email and give him or her a list of the issues and see if it's something they're interested in. So that's what you've done. You've identified those potential experts. You call to get them hopefully on board. You've already researched their background, their licensure. So then the call comes back in, hopefully, and you have a chance to talk to the expert about the case, and you do that. This is who I represent. This is what I believe the case is about. Here's where I think it's going to go. Is this something that you can assist with? And then you have a discussion about that, and in that discussion, you want to make sure that, especially if you retain this expert, you get a up-to-date copy of their curriculum vitae, so you have that within your grasp, and you want their fee schedule. You don't want to be surprised. I'll tell you, and Brandon will attest to it, these experts are expensive, anywhere from maybe a family doctor at $400 an hour to a neurosurgeon at $2,000 an hour. So you want to make sure that you know what you're in for with the fee schedule, the fees for reviewing the case, for giving a deposition, which the other side typically pays for, and coming to trial. Trial fees can routinely be $10,000 a day, $5,000 to $10,000 a day plus expenses. So know what you're in for, and as Brandon said, whether you can afford it. You want to make sure that you're HIPAA compliant because you're going to be sending records to these docs. So you want to send, we call it a HIPAA letter or a business associate agreement to make sure all this information is kept confidential. You want to have your nurse paralegal who has ever organized gathered and organized your medical records to get those to the physician. Sometimes they want hard copies. Sometimes they want it on a disc. Ask for their preference and do it the way they want to do it. Then, once their review is done, typically you'll receive a call, or my nurse will get a call and say, hey, Dr. Jones has finished his evaluation. He wants to talk to Bob, and we set up at least an hour telephone conference for a give and take. What I usually do is I let the expert speak their mind and tell me what they think about the case, take some good notes, and after that I interject my thoughts on the case and have a nice give and take meeting with the physician. And finally, you want to obtain a commitment that if their opinions are good for you and you want to call them in the case, you want to obtain a testimonial commitment that they will come live at trial. I learned the hard way. Sometimes I got doctors who reviewed the records, gave me a good opinion, said, oh, by the way, I don't testify, or things like that. You've just wasted your money. So you want to make sure that you are going to get a testimonial commitment should their opinion roll the way you think it will. So that's selection of experts. We'll move on to discovery quickly. These are on the slide, the discovery slide. These are your basic items of discovery. I use interrogatories very limited. I just want to know who's involved, because more likely than not, the lawyer is answering these interrogatories and having their client sign the verification. So frankly, I use interrogatories limited to, who are the people involved, where has the plaintiff gone for medical treatment, very easy questions like that. Once we gather that, we want to obviously get all the documents. And from the hospital side, I usually have all the documents already, but I want to know what the plaintiff has. So we want the records back to compare. We'll talk about this. There are cases where independent medical exams have been used. I had a clear liability case that my only was really a question of damages, and we'll talk about this later, but the plaintiff had numerous injuries, and I frankly used independent medical examinations on every part of the body on which the plaintiff claimed injury. So that's one tool that can be used in discovery. Obviously, requests for admission sometimes can be damaging and narrowing the issues. And we'll talk about this later also, but depositions, I pick and choose which depositions I want to videotape. It gets expensive to have a court reporter and a videographer at a deposition, but I'll give you a case study later where I really was upset with myself for not having videotaped the deposition. So you want to make those good decisions whether or not you're going to do that. Go ahead, Brandon. You had some things to add.
Oh, yeah. Dovetailing from what Bob said, I have the same perspective on written discovery. You're not going to get a whole lot out of it. It should be a tool towards narrowing the case and particularly focusing you on the issues for a deposition. So the same kind of things I'm looking for is who are the players, and also is there anything missing from the chart? Are there any communications that are not reflected in the medical records or statements for the patient, et cetera, between providers not reflected in the records? I just want to know, do I have the universe to get ready for depositions? I don't expect to get anything resembling ammunition for depositions. And in terms of video depositions, echoing what Bob said earlier, I do them routinely for particularly party depositions. I want that, but from what Bob said earlier, make sure you know the pronunciations before you take a videotape deposition. There's no reason to take a video if you're not planning to potentially use it at trial. And if at trial you're playing a video of yourself stumbling over the pertinent medical language, you're embarrassing yourself 12 months before it actually happens. There is a quick question on whether pretrial settlements are common in med mal cases. I would say if you have all of your ducks in a row and it's a good case, my experience is most of the time cases can be evaluated and risk can be assessed by both sides and negotiated out. But at least in my jurisdiction, many policies for providers themselves are consent policies, so the doctors do not have to report a settlement, settlement of an unmeritorious case across in their licensure. So If the doctor will not consent, there will be no settlement.
I flipped there for you, Brandon.
Thank you. These are a few other things I'm looking for in the discovery process, particularly the written discovery process. I've found in many cases there are material changes made to the medical records after suit is filed. I've seen a prescription suddenly added into a chart of a decedent before that was not there and should have been, compared to the records that the same provider provided pre-suit. Don't assume you've got the same thing. I have somebody who knows what they're doing go through, if I don't do it myself, and compare line by line on all records. There may be a needle in the haystack that's worth the entire case. In this course of discovery, I always confirm, or generally always confirm, readings of handwritten notes, including abbreviations, medical abbreviations, whether SX means symptoms or surgery is usually apparent, but just to not walk into trial and find out you've been using different terminology, and that the doctor doesn't come to trial and say, you've been reading that 7 in my notes as a 9 the entire time, so your test results are all wrong. Always verify that those test results are undisputed. In so many cases, lacking anything else to defend on causation in particular anyway, I've had, by the time of trial, there'd be a question about whether an otherwise a seemingly undisputed result by a third-party lab done during the course of a patient's treatment is somehow questionable. So verifying we've got no disputes on that, and in all circumstances. By the way, that part I usually see in the blood work context. Sometimes in the ECG, where the computer readout at the top, computer prints its own interpretation at the top. There's some questions about those, but the toxicology and blood work I've seen time and time again come into question at some time when at the outset it's by an independent person who has no dog in the fight and looks like nobody will be challenging it. Make sure that you figure that out early so you can address it as need be in the pretrial prep. And considering causation, it's so easy to get hyper-focused on disputes about standard of care and get blindsided by a causation issue you didn't think about in the back end. For example, if a doctor should have transferred a patient to the hospital for immediate emergent treatment, you need to prove how long it would take to get the patient to the hospital and in the OR. Figuring out all those things, just because you prove at the end of the day the doctor should have at some point done X, you also have to figure out what X plus the time to get to treatment from the last time it was acceptable to do X is, and whether you have causation from that standpoint. So thinking about time for what needs to be done after the doctor's slip-up is absolutely necessary.
Let me add one thing to what Brandon had to say about the needle in the haystack. If you're representing a defendant, do not, and I repeat, not, and I can't say it enough, let your client change or alter a medical record, because you don't, that's just a big no-no, and I'll tell you, that could lead to punitive damages in a case, and that's the needle in the haystack that Brandon is talking about. An altered medical record, and that alteration, be it as small as it can be, would take a case from a liability case to a no liability case. So under no circumstances as a defense lawyer do you allow that to happen. I've had it. It's not pretty.
In the scope of depositions, there are a few things that I like to try and think about anyway in planning and taking them. One is making sure to distinguish between a doctor's or a healthcare provider's personal practices and the standard of care. And many people will say, well, I do X, but it doesn't matter what X is if the standard of care requires something different. Particularly in expert witnesses, for example, I'll hear them say, I don't think anybody has to know about this condition. It's not really part of the standard of care. And you ask them in their personal practice, say, oh, no, I know about it. I test for that condition every time a patient comes to see me. But distinguishing in the course of depositions between what the doctor does routinely and what the doctor thinks is required of him or her is important. In the course of deposing other sides, a lot of times I'll try to bolster my expert's qualifications through the other side's testimony if they revere the institution, the facility where my expert works. Get them to say, I refer all my patients along to that facility. Everyone who needs this treatment, I refer to that facility. And I try to build the foundation of exhibits to the other side. For example, if you can get the other side to say that the pertinent medical journals from their professional organizations, like ACOG for obstetricians or the emergency medicine group, if you can get them to say that those journals are authoritative, then you've got a pretty good foundation towards using the medical literature at trial and avoiding a dispute about that. Same thing for business records. You can get them to say that, to lay the foundation that these are kept in the ordinary course and et cetera, even if the defendant is not the hospital that provided the records. And lastly on this, considering 1006 summary exhibits, that's rule of evidence 1006 and federal rules and whatever the state counterpart may be. When you got hundreds of pages of medical records over a long course of treatment, the jury doesn't want to hear that any more than you do. So sometimes I will prepare a summary in advance, or by having the doctor or defendant write out a chart listing each pertinent vital sign. For example, the patient's white blood cell count on this date, this date, this date. Write it down and keep a chart, and then agree at the end that they were voluminous records that have now been summarized in a fair and accurate method, and it's a lot easier to read than to have to go flip through pages. Now you've laid the foundation for the defendant having created a chart for you. Same thing can be done with a timeline or other things.
Yeah, let me just add one point to that. I think that's a great point, Brandon, and I can tell the folks from practical experience. I was just in a nursing monitoring case, and allegedly the nurses missed the 10 o'clock round, but the important components of what they needed to check were done at other times. So I was able to put a chart together, and where it looked like a complete miss on a 10 o'clock round, the components of what the nurse should have looked for during that round were done at other times. So I was able to put a chart together and move my way through a missed visit that was very important, because several components of that were done at other times. So charting like that can be very special. Let's cruise through the next couple of slides. We're talking about depositions, and let's move to what I think is very important, our expert witness depositions. And what I've done on the next several slides is to give the audience what I think is a pretty comprehensive outline that I've prepared over the years in taking in expert witness depositions. So this consists of the next in our slides, and we'll go through these quickly, but next probably 8 or 9 slides. So I look at expert witness depositions in 3 parts. Part 1 is to gather the professional background of the witness. Part 2 is to look and see what the expert reviewed in this particular case. And part 3 are the opinions. So let's just talk about that quickly. Obviously, as you look at this particular slide, we're looking at the expert's professional background, name, CV, education, etc. Now, what I like to do, if you look at number 3, I like to listen to my question and answer in my head to get a nice, concise question and answer. And if you can get the expert to agree that there are nothing in their academic background related to this case, you get them to say a nice correct on that. And so those are things I kind of look for. So we go through education. We go to sometimes seminars or workshops. Training, their training in the medical field. So their medical school, their internships, their residencies, their fellowships. I'm looking at number 5. Their employment background. Then I get into their consulting services. Routinely, these experts who work on these cases this is not their first rodeo. And so you want to know basically how much money they're making doing expert witness work, so you can cross-examine them with that later. You want to know if they've formed a consulting organization, John Jones, MD, Inc. and sometimes all the money goes there. So you want to know who's the owner and participates in that money, what their relationship is to the organization. As we slide down number 7, you want to know, are they 100% for the plaintiff and never consult for a defendant. Things like that. In federal court, as everybody knows, experts for a period of time need to keep a list of cases in which they've given expert testimony. Do some of these witnesses have that list, and you want it? You want to identify what I think is important, the type of case that you have in this particular case, where they've maybe been retained. If they're testifying for the plaintiff, I want to know if they've testified on similar issues for the defendant, and gather those depositions that you can use for cross-examination later. Let's see. You want to know if they've ever been found disqualified from any court from testifying in a particular area, and whether they advertise. You want to go through their publications and writings, anything pertinent to the issues in the case. You want to talk about their teaching. I could tell you in Ohio they can't be a professional witness. They must spend at least 50% of their professional time in the active clinical practice of medicine or teaching. So you want to go through their normal week and how much time, what's their total professional time, and break that down into patient care, clinical care, teaching, administrative, and see if you can't knock out the expert that they're less than 50% of their professional time in the active clinical practice. So you want to go through all of those issues. Again, I've put this outline together over years of seeing and hearing good lawyers take depositions. Let me see if there's anything else on the background. Lectures, presentations, memberships, societies, licensures, things like that. And also look at number 15. Do they even hold themselves out as an expert in this particular field to the medical community? So those are the qualification, or the first part of an expert deposition that you want to thoroughly explore. And again, you don't have to do it in this order. Pick and choose the order in which you want to do it on a particular case. The next section is the subject case, section 2. And you want to know everything about their initial contact, what they were told. I find sometimes, for example, on a radiology case, I like to send my radiographs blind. I don't tell the expert. I mean, obviously they know a lawyer studying the case, but I want a blind review of the radiograph. I don't want to tell them anything except what the clinical information that the radiologist had at the time. And so they can give me a blind read of the scan. I can't tell you how many times I go through an expert's file in a deposition, and the first letter from the plaintiff's lawyer is, hey, thanks for reviewing this pulmonary embolism case for me. And, I think that the expert can't not give you a true blind review of a case if they know the end result. So you want to know what information they've gathered from the initial contact, et cetera, and get all their communications with the opposing lawyer. You want to review their file materials to make sure that you see what they've seen. And then some of the other topics. Kind of the chronology of their work on the case is number 3. 4 is, again, chronology. 5, have they done any research on the issues? Have they talked to the parties or witnesses, consulted with their colleagues, done calculations, and written any notes or reports? You want to get all those and mark those into evidence. And finally, we get to really one of the most important, or if not the most important part of the expert deposition, are their opinions. And the bread of the opinions I like to do this way. It's the first bullet point and the last one. Do you believe you've done, and I ask this word for word, every case without exception, do you believe you've done everything you need to do in order to form and state your opinions in the case? Get all those opinions on standard of care, causation, damages, and any other issues that you've identified or your expert has identified who should help you get ready for this deposition. And then after we get all the opinions, you want to make sure that you've discussed each and every opinion that has been made and expect to testify at trial. You don't want any surprises later. So this is an outline for your assistance. If anybody has questions, they can feel free to send me any emails on that, but hopefully that'll help you out. Brandon, go ahead.
And I'll say on the plaintiff side, depending on the rules of your jurisdiction, the judge, and the particular expert, you may consider not deposing experts at all. I've had defense lawyers, when I've said that, freak out and ask if I've had one defense lawyer who I gave a speech with saying that they had researched whether they could file a motion requiring the plaintiffs to depose their experts because they wanted to hear how the expert would hold up in a deposition. I'd rather not give over any points that I might use in cross-examination if I can rely on the judge to hold them to their disclosures based on the rules in the jurisdiction and based on the judge's general personality, or if I've got enough from the expert's publications, testimony, other sources, etc., if I can get through an effective cross-examination without having to pay that expert ballparking at $5,000 for their time, somewhere between $2,000 and $5,000 for their time in order to tell them what I'm really interested in about their opinions, I just assume not to do a deposition.
Well, that's interesting. Next, quickly, we're to just talk a little bit about motion practice, and I can tell you that some of my business cases we file motions to dismiss, rarely in a med-mal case. In business, I mean healthcare litigation business cases, which are non-competes, joint venture problems, things like that, sometimes motion to dismiss. Brandon will tell you rarely are there motions for summary judgment. Maybe a partial motion for summary judgment will be filed on a particular issue, but rarely are motions for summary judgment filed unless the opposing expert has just taken a nosedive on a case, and if the plaintiff's lawyer won't dismiss your client, then you file the motion. The one thing I want to mention in particular are motions in limine. I use motions in limine extensively in my cases. It's not unheard of in big cases. Recently, in the last 12 months, I've been in 3 trials which consisted of about 18 weeks. And I can tell you that on some of those cases, I filed upwards of 12 to 15 motions in limine on issues that had arisen in the case. And I will tell you that it's not only to keep things out, but I want some preliminary rulings that on some issues that may be close to the line, whether I should bring them up or not, I want the court to know I'm bringing them up, and I want a ruling in advance whether I can do that, so I don't run afoul of any rules or mistrial problems. So I like to use motions in limine extensively in these cases to narrow the issues and find out what I can and cannot do at trial. Brandon?
I agree entirely, Bob. I can count on one hand the number of summary judgment motions I've seen in med-mal, including partial summary judgment, outside of really narrow claims or defenses. But from an evidentiary standpoint, I can't remember the last med-mal case I had go to trial without at least 10 from every lawyer in the case, including motions to allow things like per diem arguments and et cetera. There's enough planning that goes in that you need to know what your strategy is going to entail and not have a flow chart about, well, if the judge stops me here, then I'll go this, and if the judge stops me here. You got to know the key evidentiary rulings that you're likely to encounter before the jury's even brought in for voir dire.
Absolutely. I want to know what I'm playing with. Before we get started. Let's go to the next section quickly. We did have a question. I think that maybe Kathleen can respond later. One of the questions was, can the folks listening in get a copy of the outlines that we have? And I'll let Kathleen speak to that at the end. But one question we had here, and I'll get to it right now, trial is medical education. I, in every phase of a case, want to educate that juror on the medicine as I see it in every aspect, whether it's voir dire, opening statements, witness examinations, direct or cross, and closing arguments. Sometimes I'm told I beat a dead horse, but I tell you, I think juries remember between 3 and 5 points And those 3 and 5 points, that's my medical education, and I hammer those things in all facets of the trial, in voir dire, opening statements, witness examinations, and closing, where I have this jury understanding this case as I understand it and going to go the way that I want them to go. There was a question here. If you had to ask only 3 questions during the jury voir dire, what would those be? And I'm going to answer, and I made a list here as I was listening. If I had to ask 3 questions from the defense side, it would be these. 1, I want to talk about the burden of proof, and does the jury understand that the plaintiff has the burden of proof, and I, as the representative of the defendant, have nothing to prove in this case. In fact, I don't need to do one single thing. That's number 1. Number 2, I'd come up with some catchy question regarding the main medical issue in the case. So I'd find your medical issue and come up with a question that gets people talking. And the third thing from a defense standpoint is usually these cases are about a lot of sympathy. And can the jury set aside that sympathy and despite the loss, could be of a young child or a providing father, those folks that Brandon represents, can a jury find for the defendant despite what everybody believes is a very sympathetic case? So those are the 3 I would ask if pressed in voir dire for only 3. And I tell you, I would know my rules because I want to, in voir dire, go as close to the line as possible and try my case in voir dire the best I can, unless the judge cuts me off. If they let you go, keep going. Brandon?
I think, okay, my 3 would be the exact same thing you said, but said from the plaintiff's side, so hopefully before you got a chance to do yours. We have the burden, but that burden is more likely than not. Is anyone in here going to insist that we prove beyond a reasonable doubt or 100%? Can you agree with me that if you just think it's probably true, that's enough? And number 2, it's got to, it's vague to say, but it's got to be tied to the particulars of the case. I've got to know probably either a catchy phrase or anybody on the jury lost a loved one, or any of you particularly had the same condition, what kind of treatment did you get, et cetera. And the third one is the flip side of the sympathy for the plaintiff is, can you find against this doctor, healthcare provider, even if you believe he was trying to do his or her best? So
that's a good one.
The same sort of, the same approach.
And I'll tell you, I'll let Brandon speak to this also, but I find that plaintiffs make a lot of mistakes in closing arguments. You got to ask for money. I mean, I'm a defense lawyer, and I'm amazed at how many times a plaintiff doesn't put a specific number on the case. I don't know if Brandon disagrees with me, but it's always backfired on every plaintiff that didn't ask for a specific dollar amount in closing argument. Brandon?
Yeah, Tennessee, where I practiced, until about 7 years ago, it was unclear whether you could ask for a dollar amount in a medical malpractice case for a variety of reasons. We finally got a Supreme Court opinion that says you can, and it's a godsend. You absolutely need to, in any personal injury case, implant in the jury. As a plaintiff's lawyer, I am not afraid of the jury thinking that I'm greedy for asking for too much, because before I've ever stood up, when the jury hears I'm a plaintiff's lawyer, they already think I'm greedy. They assume I want whatever money they put on the table, but everybody's got to have a frame of reference. If you went in negotiating to buy a car and you had no idea whether there was a difference between a Mercedes and a Ford, you have no idea what dollar value to put on it if you've never heard what a car costs overall. Well, juries have only heard what they've seen on the news. That most of them think the McDonald's verdict, and they got that wrong. If you don't tell it to them, you're not going to hear it.
Okay, I think there's a poll question next, and I will tell you, I've had the MedMal Navigator Prime presentation, and I'll tell you what, that's an amazing tool. For those of you that do medical malpractice work, it's absolutely amazing.
I'd agree with Bob. I sat through it, and it does give resources on the fact side, including experts, and on the law side, including the 101 ways you can lose a medical malpractice case.
Right. I know we're coming up to our end. Let me just say a couple things about some case studies that I've put in the slides.
I did see a note, Bob, by the way, that Lexis can send you the all the slides to the audience.
Yes. Okay. Wonderful. Wonderful. Let me get. I have some case studies here. When you get the slides, let me just talk about them real quick and what the point is. And if you want to take some notes, then you can go back and look. I tried to give some cases that these are real-world cases I've worked on, and let me just tell you the points of some of these cases. The point of case study number 1, which was actually a QTAM False Claim Act case, a Medicare fraud case. This is the one where the plaintiff had to prove that my clients knowingly violated the law, and I had the plaintiff's expert in the deposition not videotaped. And I had this guy all twisted up on the law that he said it was ambiguous. I had his head in his hands. So here's a guy with his head in his hands. I did not have him videotaped. And he was able to admit to me that my clients could not knowingly violate an ambiguous law. So that's one where when you're thinking about videotaping a witness, you want to do that. That's the point of that slide, case study 1. The point of case study 2 was it was a allegedly missed heart attack case, and the one thing that I want to show you, I'll go to the next slide. This is kind of a chart we put together. I had 4 doctors who saw the patient in the hospital, and never thought there were any signs and symptoms of a heart attack or myocardial infarction. Well, these are all the other people that rounded on the patient also, and on their particular days of 2 weeks, and none of those people thought it either, and some of them had the same training as my perioperative specialist. So I was able to use this type of charting in that case to show not only did my clients not recognize anything, which there was nothing to recognize, but nobody else did later.
If I could jump in right there, Bob?
Sure.
And I do the flip side on the plaintiff. I file a motion in limine on that exact topic. Other than healthcare providers who have the same degree of training and are in the same medical specialty, I move to prevent the defendant from mentioning or making any argument that so-and-so also missed it. If a physician assistant missed the diagnosis or missed the treatment, et cetera, I file a motion in limine to keep that off because, as Bob described earlier, one of the most dangerous things for a plaintiff is an empty chair.
Oh, yeah, because in this case you had not only my guys, the perioperative folks following, but you had orthopedics, endocrinology, general medicine, infectious disease, and nursing. And so obviously Brandon and I would fight over that motion to eliminate.
Oh, I've never had it granted by stipulation. It's just a frequent topic at pretrials.
Right. The next one was the whole point of this case study. It's a lady who got the wrong blood in surgery. Her name, they didn't do the correct match. The name sounded similar, so she got the wrong blood, had a hemolytic transfusion reaction, meaning her whole body shut down. And it was a clear case of liability, but she claimed the world and injured every part of her body from the hair on her head to the toenails on her feet. And so I identified the most important bodily systems and went through each with independent medical exams to really knock down the damages in this case. And I think the next one was, unfortunately, one of my hospitals had a nurse stealing Dilaudid from a medication dispensing machine. The whole point of this one for the plaintiff's bar is you better do your discovery in the case, because the plaintiff's lawyer didn't do his discovery, and he would have found out in the case that the machine from which the medicine was being diverted was not the machine from which his client's medicine came. So there was no connection between the two. So in other words, better do your homework, because he spent a lot of money trying this case and he had the wrong machine. Finally, this was a bad case I defended for about 6 weeks. It was alleged injury in the emergency department. I contended that the injury occurred sometime else later. But the point of this slide is, once you read about the slide, One thing I like to do is I have a medical illustrator on staff, and he actually drew these, the anatomy of the cervical spine. And what I tended to try to prove in this case, here's your anatomy. The plaintiff contended that he got injured in a flexion extension injury where, as you can see, here's the injuries in the where you would expect a flexion to occur, and plaintiff's injuries occurred on the opposite side. So I used an in-house medical illustrator to show that this didn't happen the way plaintiff said it did. And finally, the last case was a case that is you should consider using exemplars. Exemplars are other radiographs to show what the plaintiffs believe should be in this case. So this was a pulmonary embolism case, and if you look at these slides, the IVC, or the inferior vena cava, is here, and the aorta is, there are two circles. You probably can't see my cursor, but the slide on the left is the patient. The slide on the right is an exemplar of another patient where the IVC and the aorta are different sizes, and that's normal. And if you go to the next slide, which I believe is wonderful, it talks about contrast and how your inferior vena cava looks with contrast if there's a clot below a filter. And the one on the left is the patient where it looks dark, and the one on the right, you can actually see the clot under the filter in the inferior vena cava. And this was used to show that there was no way the radiologist saw on the subject film what was to be seen. So exemplars are another way to go on some cases. I know that we're out of time. Brandon, anything else to add?
I do not, and I agree on the exemplars in particular. If you're relying upon the jury to understand any kind of visual evidence you're putting in front of them, giving an anchor so that they understand what it would look like similar to your client or different, similar to the patient, or what is different from the patient is absolutely necessary, rather than asking them to take the expert's word for it that this patient is special or this patient is like everybody else.
Sure. And I think there's one last question. Are you both on LinkedIn, and how do we connect with you there? This is Bob. I'm on LinkedIn. Robert B. Graziano. You can connect with me. And Brandon, are you?
I'm on LinkedIn as well, and I think the guy who asked for it already got me. So.
Yep. Okie doke. Well, we appreciate everybody listening, and thanks for the questions.
Thank you so much, and on behalf of LexisNexis, I would like to thank Brandon and Bob for today's excellent program. Please feel free to contact them directly if you have any questions that you'd like to explore further. All attendees today will receive a resource guide and a recording of today's webinar. If you would like a copy of today's slide deck, please contact Jared Bantz, JARED_BANZ at LexisNexis.com, and he is happy to provide you with a copy of today's deck. This webinar is the first of a three-part series on A Day in the Life. Look for additional information about upcoming series webinars. As a reminder, please complete the survey that will appear as the webinar closes today. If you'd like to stay in touch and get helpful legal news and resources, please follow us on our Twitter feed at Lexis Small Law. Thank you all, and have a great day.